Welcome back to News Talk. The battle to keep former Virginia Governor Bob McDonnell out of jail continues. The governor, you'll recall, was convicted and sentenced to 2 years in prison after a jury found he used his position to get gifts and loans from a businessman seeking the state's help. A huge coalition of McDonnell allies has been working ever since his conviction to get the verdict reversed, and the matter is now pending before the United States Supreme Court. Attorney David DeBolt is part of that effort, and he joins us now. Welcome. Good to have you here. Where do things stand in terms of the fight to keep former Virginia Governor Bob McDonnell out of prison?
Well, this is really the last stop on whether the conviction will be affirmed or whether it will be reversed and either vacated altogether or sent back for a new trial. The Supreme Court takes very few cases each year, and it took this one to resolve the issue of what the scope of an official act is in the context of a prosecution for bribery.
So there's no debating or doubt that Johnny Williams, the businessman, and Mrs. McDonnell had a close friendship, and that Governor Bob McDonnell, while he was in office, knew who Johnny Williams was. The issue, the issue was there a quid pro quo? Right. Were there gifts and loans and things of value like use of a vacation home given and accepted in direct exchange for something that materially helped Mr. Williams get his vitamin firm up and running, to make it more profitable, assistance with state research or what have you, and that's where the whole thing sort of lives or dies, right? Can prosecutors establish a connection between all the things that were happening back at the time they were interacting with one another?
You're right that the key issue here is whether there was an exchange of something of value, gifts, loans, etc., use of a vacation home, for something that the governor was not allowed to make available, which was his exercise of official power, the exercise of the power of the state. And what it comes down to is whether the things that the jury was allowed to consider on the quo side of the quid pro quo were actually official acts, or instead whether they were things that normally are done by politicians as a matter of giving access, hearing people out, listening to their views, but not actually taking any action. The governor didn't authorize any funding for Mr. Williams' business, nor did the jury have to find that the governor pressured anybody who worked for him or with him to give that kind of financial assistance to Mr. Williams. So it's the line between taking an act on behalf of the state and merely providing access and listening and doing what politicians typically do.
There were emails where he communicated with people in the government saying, could you talk with so-and-so, or could you meet with them? Are you and the other allies that Bob McDonnell has working on his behalf now so familiar with all of the communication to be able to say he was nice to Mr. Williams, he helped arrange for interactions with different people in the government, but was careful in each and every instance not to say, hey, there's a contract I think he'd be perfect for, or let's do something for him, or let's move forward on this research that he's seeking. I mean, at one point, I think Mr. Williams actually wanted all state government employees to take some vitamin supplement because he thought, what a great and large sample size or group of people this would be to I don't know if it was do research on or whatever. Are you and your team so familiar with all the communication that was had around Mr. Williams to be able to say with confidence he was polite to the guy but never really did anything?
Well, we're familiar enough, and I represent a group of former federal officials who filed a front of the court brief in support of Mr. McDonnell, not so much in support of his particular case as the fact that the jury instructions that were used here, the jury was told that what it needed to find as a quote-unquote official act was so broad that it threatens the way politicians, officials, other public employees do their day-to-day responsibilities. But I am familiar enough with the underlying facts to know that the government really pushed the jury to ignore whether or not this was just interaction where he's hearing out somebody who has a view and he's asking other people to listen, which is normal everyday political conduct. And they said, don't worry about whether Mr. McDonnell pressured other people to make a decision in Mr. Williams' favor. And that's really where the line is. If he had himself authorized the funding for Mr. Williams' supplements for the medical testing, or if he himself had pressured other people or tried to push them to make a decision that would favor Mr. Williams, the Supreme Court would not have taken this case. But the jury was instructed that official act is basically anything that an official, a public employee, typically does, whether it's spelled out in statute or not. And it doesn't have to be the final step. It can be a beginning step, which, of course, all sorts of access to government officials is. It's a beginning step. It's a foot in the door so they can get an audience. And that's really what this comes down to.
Bob McDonnell is a Republican. Your group is remarkably bipartisan. You don't just have one or two token Democrats, I'll call them. You've got many people who've served, who are learned in the law.
Yes.
Can you talk about the extent to which your group is bipartisan and what the existence of such a bipartisan group says to you about the merits of your side of this argument?
The bipartisan nature of our group speaks to the point that this is not a partisan issue. This is not a Republican issue. It's not a Democrat issue.
You have like 20 former attorneys general on the other side?
Well, there's a separate brief, on the other side where they have other. But we also have a number. We have, I think, not our brief, but another brief on behalf of the petitioner, on behalf of Mr. McDonnell, is a group of former Virginia attorneys general. Our group is pretty evenly split between Democrats and Republicans. We have counsels to the president, the lawyer who specifically advises the president, that served every president since Ronald Reagan, so including Clinton, including Obama. And the reason why they were willing to join on to the brief is that it's not about what Governor McDonnell did. It's not about whether the voters should have been unhappy with his conduct. It's whether the way the jury was told to think about an official act was so broad that the government could threaten really any politician, any political figure, any federal official or state official for that matter, with a possible criminal investigation based on giving people access and hearing them out.
A lot of what a local leader does at the mayoral level, county executive, governor, what have you, is boost the economy of the area they're elected to serve. So they have interactions with business people all the time. In this case, Robert McDonnell ran under the slogan, Bob's for Jobs.
Bob's for Jobs, yes.
Not for nothing is he interested in growing the economy of his state. And what does that mean? It means helping the private sector entities within the state, within, of course, the confines of the law. Can you talk about the death of former Supreme Court Associate Justice Antonin Scalia? The court is now 4-4.
Right.
Many people see the court is now short one member.
Right.
They have 8 instead of 9, and many observe an ideological divide. Can you talk about how that impacts your case? Sure.
Justice Scalia, as you know, was very skeptical of the government pushing the limits of laws. He, in the case of the honest services fraud statute a few years ago, was prepared to declare the statute unconstitutional because it was so vague. This was the statute that was used in a number of prosecutions to get at basically undisclosed financial interest rather than what it's now confined to, which is bribery and kickbacks. The loss of Justice Scalia is probably works to the government's advantage here because he wrote an earlier opinion, which is cited prominently in the various briefs, in which the government was really pushing the idea that a gratuity could be prosecuted. You could prosecute somebody for a gratuity based on such trivial things as whether a Secretary of Agriculture went and spoke to a group of farmers and received a token gift as a result. Surely he's doing what he would do as an official, speaking about matters of interest to the farmers, and he's receiving something in exchange. And this case really is no different from that, except that the government has a lot more on the quid side. But quid pro quo, it doesn't matter how much you have on each side. If you have any amount on one side and any amount on the other, you've got the basis for a federal prosecution.
We only have a couple seconds left. It has to be enormously stressful for Bob McDonnell and those who care about him at a personal level. Have you talked to him? How's he doing?
I haven't talked to him myself. He's been very grateful to those who have supported him with emails after every brief has been filed. He's really a very generous person in terms of his thinking of people.
Do we know when this comes back before the High Court?
The argument will be next week.
Wow.
And the decision will be in June.
Attorney David DeBold, part of the legal team working to keep former Virginia Governor Bob McDonnell from prison. Thank you very much for your time today. Interesting set of issues. Good to have you here today. We'll step aside, back with more in a moment.